DepSec corporate. On my left, in her role 3 weeks, I have Caroline Graney, who's now the DepSec policy. I'll just quickly run through the next row. Erin Judge reports to me as the chair of the Justice Sector Leadership Board. So she also has a responsibility with towards the other chief executives in the justice sector. We have Bex Parrish, who knows all about the numbers, and we might call on her at some point. Sam Kanowski is a GM from our policy area, and he's here as insurance in case Caroline's 3 weeks proves too short to answer her questions. Sheridan Smith is standing in for Marcus Akuhata Brown as the DepSec Aotearoa Strategy Group. We have Tracy Bagley. You'll be missing Carl Crafer, who's actually overseas at the moment. So Tracy Bagley is the acting Chief Operating Officer, and the rest of the time is the Legal Services Commissioner, which is a statutory independent role from the rest of the ministry. We have Karen Samuels, Victoria McLaughlin, who's the DepSec over the case management program, which we've briefed you about. She's away, but Karen is standing and acting as the DepSec there, and Andy Fulbrook, who's our CFO. It's an honour to represent the Ministry of Justice, Te Tahu o Te Turi, here today. Our purpose statement, to strengthen people's trust in the law of Aotearoa New Zealand, does guide our work each day and be a reference point I think we come to more than once throughout this afternoon's session. We've remained focused on this purpose through a challenging and interesting year, a change of government, busy work program, and a tight fiscal environment. I think it's been, in many respects, a challenging year, but a very good year for the ministry, and I'm proud of the efforts of our staff as we support all three branches of government. Remarks in the policy space. Law and order, of course, is a priority for the government. It's meant a busy year for our policy team. They've delivered a lot of high quality advice, starting with the government's 100-day plan commitments. The committee will have seen evidence of that work as justice officials have regularly appeared before you over the past year. There's been a big work program. Obviously, the new gang legislation, 3 strikes, firearms reform, sentencing reform, foreign interference, remote participation in courts, and of course the Treaty Principles Bill. That's shaped a lot of the policy discussion. In the operational side of the business, we know that reducing court delays is a key to improving access to justice, arguably the most important thing that we can do. In that world, the Chief District Court Judge this year has introduced a new timely access to justice protocol consisting of a timely access to justice standard and category-based timeliness thresholds for criminal cases within the District Court. They set a standard he hopes for the system to achieve of 90% of cases nationally being disposed of within those deadlines by 2027. As of October this year, we're running at about 81%, so that's part of the gap that we've got to close over the next 3 years. The current performance has stabilised, and I'm sure we'll talk about it some more. There's some good signs of improvement in that space as we go forward, and we're at 81% at the moment. Ministries work with the Judiciary, New Zealand Police, Department of Corrections on the timeliness work. There's been a lot of operational initiatives which have pitched in that space. It is paying off, particularly in the Auckland metropolitan area. We've seen adjournment rates improve. We've been seeing the proportion of cases sentenced on the same day as a guilty plea improve. In Tamaki Makaurau, it's gone from 40 to 45%. Timeliness across the Auckland courts has improved over this last year by 71 to 73%. We've continued to embed Te Ao Marama, a judicially led vision for the District Court, designing services to meet local needs, finding local solutions that will see a change that will continue. The digital case management work, Te Oreka, which Karen's here to talk to, is well underway. We will have preparations for the Family Court Bill to begin in 2025. And we've made real progress, I think, in the state of our courthouses, particularly noting Papakura and Wanganui announcements that came out today. So as we look across the board, we have seen a lot of change. The fiscal targets that we've faced in the last year have meant we've had savings targets to meet. We've done that. We had a net reduction of national office roles, about 127, and from there we've basically look to put ourselves on a fiscal footing that will help us as we go forward. Conscious of time, conscious of my instruction, and somehow that 5 minutes passed very quickly, Mr. Chair, so I'll draw that to a close there and welcome discussion with the committee.
No, thank you, Andrew. And I think busy workload is a bit of an understatement for the hearing. So just in terms of how the hearing will run, I understand there'll be a lot of topics and issues that members may well be interested in asking questions about that are before the committee. So just ask members to be cautious about making sure they confine their questions to the work plan or the work done undertaken in the financial year under review, and also the strategic intentions of the ministry. Just be cautious about discussing items of business that are before that may still be subject to confidentiality. But in saying that, I will hand over to whoever wants to take the first primary. We'll go to Duncan.
Yeah, got a theme that I'd like to pursue here, and it's centred around the key priority of achieving better justice outcomes for Māori, and just aware of your role as leadership of the justice sector. And we've had corrections and policing. And I guess my first question is, what exactly is meant by better justice or better justice outcomes for Māori? Exactly what is it that we are aiming for?
Okay, thank you for that question. So you have to, I think, start, as I flagged in my introductory remarks, with what is our purpose. Our purpose is improving trust in the law of Aotearoa New Zealand. That's a purpose that applies to all New Zealanders. Within that, we know the trust levels of Māori from survey are in the system are lower than they are for other New Zealanders. We know that the outcomes that Māori experience in the justice system, most notably as victims, but also as offenders, as those who are incarcerated, are higher for Māori. We know in the family violence space that the statistics of victims and perpetrators of family violence, there's a disproportionate impact on Māori. So the point of that key priority is recognising that there is a particular need, and that for us to lift the performance of the justice system in order that there will be trust from all New Zealanders in the justice system, that is an area that we have to do some work on. So we would be looking to address some of be aware of those outcomes, be aware of how Māori interact with the court system and some of the feedback we get from there, as we are of all other New Zealanders, but recognising that there is a particular need in this space because we know that many of the current outcomes are poor.
So, okay, so in terms of your overarching objective of a trust in the system, you mentioned in the disproportionate number of victims, disproportionate number of incarcerations, and disproportionate victims of family violence in particular. Is that how you're measuring success on because they're actually measurable, at least in a sense. Is that how you're measuring success against this outcomes for Māori?
Absolutely, we're measuring success in those ways. We're also looking at overall impressions of how New Zealanders view the justice system and how they feel about the justice system.
In terms of that, because that leads me on to kind of my second thread, which is around government's program. You've been giving advice on all kinds of legislation, and it's probably easiest if we run through some of it. But I mean, it's defunding Section 27 reports. Does that contribute? Did you advise that would contribute to better outcomes for Māori or worse outcomes for Māori?
No, our advice on that would have recognised that more Māori were enjoying the benefit of Section 27 reports, and that would have been a consequence of that decision to defund. But in the case of Section 27 reports, I mean, you've got to look in the round at what they were trying to do and how they were working. We actually began work under the last government because there was a clear problem definition in that space that Section 27 reports were not working as well as they should. So we were having a good look at that anyway. So
and you gave 4 options in your RIS, and the one that was worst for Māori was the one that was chosen.
Well, again, when you talk about, I mean, our RISs have obviously been largely published, so people will be aware of what our views on these issues have been. Our job is to give that advice to ministers and decisions are taken.
So, in terms of the gangs bill, which now passed, what advice did you give to the government in terms of whether it would improve outcomes, justice outcomes for Māori there?
Well, again, the advice in the gangs bill was recognising the problem that ministers were bringing and articulating, and that was that people were not feeling safe, they were feeling intimidated by gangs. There was a number of policy proposals there. Again, our advice on those proposals is clear. We talked about where we had seen the evidence of gang patches and bans and the like working and what we thought the implications of that were. We did note in that case that there is a disproportionate number of gang members are Māori, and there would be an impact on Māori as a consequence of that. But you would look at that in the overall objectives of the policy, and that's, again, we understand the objectives ministers are trying to seek.
There's a bit of a theme, right? Because if you go to the other piece of legislation, which is going through, 3 strikes, your advice there is public as well. And that was the same, wasn't it? That in fact, it would exacerbate overrepresentation of Māori particularly in the correction system.
Well, indeed. I mean, in our RISs, they're publicly available. Part of how we increase people's trust in the law is we give our advice. We've had a good hearing from ministers, and ministers have made their decisions. And
in terms of every one of those RISs, not one of them consulted with Māori before it reached policy decisions. Isn't it your role as lead in the justice sector to engage with Māori on policy proposals?
That can be part of our role. Our role is supporting the government. It's giving our best advice on how to approach things. It's being free and frank with that. And when ministers make a decision, we will take that decision and give our best advice how to implement it.
Well, I mean, you've got a new Minister of Regulation who says that good regulatory practice is to consult with the people who are most affected before implementing and developing policy. Did the ministry try to engage with Māori?
Well, in most of these cases, we would have talked to ministers about the how you balance the desire for consultation and the desire for pace and speed, which was a clear priority for the government. And as is always the case, you have trade-offs. You have trade-offs about how quickly you take business through, how quickly decisions are taken, when they're implemented, and how much consultation you can do along the way.
And then we've now got the Treaty Principles Bill, and when you provided advice on that some time ago, you noted that the lack of consultation would leave Māori excluded from meaningful participation and alienated. That's from the RIS there. How is this bill, how is all of this program achieving in any way your stated objective of better outcomes for Māori?
Well, we look at our overarching purpose, which is to improve trust in the law of Aotearoa New Zealand. There's a range of ways we do that. We do that through the content of our advice. We also do that through supporting the government and the democratic institutions of the day, and that means we give our best advice and we then support ministers with the decisions that they take around that advice. And again, in the Treaty Principles Bill, our views have been quite well documented, both in terms of the RISs, in terms of evidence we've given to the Waitangi Tribunal. But we had the opportunity to express those views, and that's, we can take these things so far.
How many people are working within the ministry on the Treaty Principles Bill?
It would vary. It goes up and down. At the moment, there's probably 3 or 4.
Yeah, I would take 3 or 4.
Are you engaging any consultants to assist?
Or just hold on that
No.
line of questioning somewhat, because there are some.
So,
Maybe
perfectly reasonable question.
That's fine.
For the last financial year.
But yeah, that's right. We've got a constraint to last financial year. And I'm not trying to shut that line of
Well,
questioning.
no, that's not what standing orders say. Standing orders are quite clear that in an annual review, you can ask questions about the financial year and things that flow from it. The Treaty Principles Bill is a piece of policy work that the government has undertaken, and this is a natural question which flows from the costs of a policy decision.
That's fine. I just want to be wary of some decisions that may or may not be before select committees and being wary of treading into that.
I'm not asking anything.
Well, I don't want you to say what you are or aren't asking. But I'll invite Andrew to answer, but I just wanted people to bear that in mind.
We haven't engaged consultants in terms of preparing our advice on the bill. We are engaged in some support to analyse the submissions we're getting on it.
All right. I just want to move on then to other matters touching on Māori. I see that the iwi chairs have ceased cooperating around the National Action Plan on racism. Why? What was the reason given for that?
Well, to get a full discussion of that, you'd need to talk to the iwi chairs. I think the view was, they had been involved in the process to that point. We were evolving that product as you would expect with a new government, and they would prefer not to be part of the evolution of that product.
And have you made any meaning, because that's been a program for some time, and from all the documentation I've seen, there doesn't appear to have been a lot of progress on it. Are we getting anywhere on the National Action Plan against racism?
Indeed, we are. We have advice that'll be before ministers shortly in that space.
So look, I guess my problem is this, and I'll stop here, but you've got some programs, Te Ao Marama being probably the main one, which is a judge-led program in 8 district court locations. Isn't that just, isn't that window dressing against a tsunami of legislation which overtly puts Māori backwards?
That's not how I would characterise it at all. I think Te Ao Marama is a program that's actually not just oriented towards Māori, it's oriented towards all people as they come to the court, so that they can get a hearing that will lead us to better outcomes. And you do that by how you engage the community. But Te Ao Marama is about how everyone experiences the district court, not just about Māori.
Do you think your mission of better justice outcomes for Māori has gone forward or backwards in the last 12 months?
I understand.
Well, I don't have specific statistics on that at the moment. I mean, you could look at it in terms of the overall crime levels, which bounce around a lot. That the target that we have in that space, violent offending, it had gone up, it's come back. There's quite a lot of volatility in some of those numbers.
Right. Okay, supplementary from Lawrence.
Thank you, Mr. Chair. One of the things, sort of picking up from sort of the relationship with Māori, one of the things that the Minister of Justice advised during the gang legislation bill was that, looking at the regulatory impact statement, the ministry pretty much advised that the gang legislation bill is going to make everything worse, except for making the communities feel, not genuinely safer, but feel safer. And that was the official advice from the Minister of Justice. But then when we questioned the minister around that, the minister's response that this is enhanced roughly around the area is, well, they can advise that, but then this is what we campaigned on. We don't have to listen to it. I guess from your perspective is, when you are making these reports and making these recommendations, what sort of conversations do you get to have with ministers or with other departments around sort of why you reference or why you written the report in the way that you've done?
Yeah, I think I wouldn't quite characterise our advice in as starker terms as you put it. I think our advice was that we couldn't find the evidence that the gang patches would make the sort of difference that would meet the intention, but it wasn't quite as bold as you characterised it then. But I would say, I mean, as you can see in that, we've given very robust advice to ministers that captures our best view, and that goes for the various other items that have been discussed. That is how we give effect to our role. It is how we support the institutions of government. I would say we've had a very fair hearing from all of the ministers that we've provided that advice to. As you would imagine, we've had points where our advice and the ministers' views have not aligned, but we've actually had a really good discussion around that. And there was quite a lot of advice that we gave through the gangs legislation and a number of other bits of legislation that was picked up and was built into the system. So there's a lot of discussion, and I think it's actually a very healthy thing that there's a lot of discussion where we bring our advice and ministers make the decisions, having had the benefit of all those different perspectives.
Okay, we'll go subs from Rima and then Takatu.
Hello, thank you for being here. Just supplementary to my colleagues' line of questioning. Do you feel that do you feel that the community is actually safer or only feels safe when illegal guns are being seized out of the hands of gangs and out of the community? Would that lead to communities being safer or still just feeling safe?
Certainly. So I think you're talking about the prohibition orders on firearms. I think you are taking guns that individuals shouldn't have them. And our advice, I think, was
I'm talking about the result of the gang legislation being that as well. Illegal arms are being seized. That's what I'm talking about.
Yeah, I think removing illegal arms from the community will always be a thing that will enhance public safety, I think.
Takatu first.
Kia ora. I'm just going to pick up on the reducing the overrepresentation of Māori theme in justice. So we've heard from corrections and police already, as you could imagine, and it appears to me that they have a severe lack of targets, no targets for reducing anything to do with overrepresentation of Māori. Again, it produces a couple of problems, obviously. If you've got staff of 10,000, 15,000, they don't know what the target is, and it's hard to measure how much effort to put into it. But given the long-standing nature of this problem, overrepresentation of Māori throughout the justice system, and given that you're the parent, the overarching arm of that, what performance measures do you have in place for the Ministry of Justice as the responsible party for corrections and police? What performance measures do you have in place for yourself and for the others to reduce the overrepresentation of Māori in the overall justice system?
We don't have specific targets that we're holding ourselves to. We are tracking the impact on Māori across a whole range of different statistics. So we're tracking the impact, obviously, incarceration and victimisation. We will ask questions. When we did the Access to Justice survey, we asked questions about that broke out how Māori and other groups experience the justice system. So it's actually, I don't think it's as simplistic to have one or two targets, but I agree with you that it's actually an important thing to track. It is a real measure of need, and we do track it in a range of different ways.
Well, one of the targets we got to very clear with the police and corrections is that there's actually been little to no movement over a long period of time. So we know how it's going. They're going nowhere. So what then is required to see some actual traction when it comes to reducing the Māori prison population, reducing the amount of Māori who have a negative interaction with the police, reducing Māori and their ability to achieve justice through the justice system? Because none of those things are coming down at all. And we have a long history to look back on. We have new reports in 2023, yet it continues to go nowhere. So what do we do about that? As the parent body, the matua body, you gotta pull some lever. So what do you think?
Well, I suspect my colleague agencies might not call me the matua body in this space. And I would invite Sheridan, if you want to come and join in this conversation, Sheridan, to do so. But look, you have identified in your questioning an unambiguous need, a weakness in the way that the justice system functions. So this is Sheridan Smith, who's our GM for strategy, and is that stand-in for Marcus Akahata Brown, who's the GM of the Aotearoa strategy group at the moment. So the questions you raise are questions about how effectively the justice system is functioning. The justice system in that context is a small part of a much bigger set of societal questions that relate to poverty, that might relate to intergenerational disadvantage and a range of other issues. All of those things contribute to the experiences in the justice system. The justice system tends to be a lag indicator rather than a lead indicator, and other forms of disadvantage will spill over into the justice system. But notwithstanding that, we recognise that, and so that has gone to a range of things about how people are experiencing the justice system. My colleagues will have no doubt talked about it, some of that experience in their place. For us, we have put an investment in over the last few years, which I think is very well grounded in what the cabinet recent Cabinet Office directive has required of us, which is need. If you think about the needs of the communities you connect with, we have invested in trying to build more capability internally so we can understand Māori perspectives on the justice system, and that has led us to think differently and work in some places. Te ao marama that was raised before is not targeted just at Māori, but it is asking the question, how has the court system been experienced by different peoples? And obviously part of that then would go to Māori as it would go to people with disabilities.
Do you have a dedicated Māori strategy? Te ao marama is for everybody. Do you have a dedicated Māori one?
We have a dedicated a framework for outcomes called Te Whao, which does go to how we think about better equipping ourselves to meet that need that we see there. Right. But I don't know, Sheridan, did you want to?
Does Te Whao have targets?
It doesn't yet. It was only launched late last year, and the next part of the work that we need to do is have the measures and the indicators, and that will help us determine what interventions are working. But if I could also add that I'll make two comments. One is around, I think I'll come back to our monitoring role across the system, but secondly, one of the other interventions that we have been able to put in place through our courts is called whakaorangia te mana tangata. And we have that in 3 locations, Kaitaia, Gisborne and Kaikohe, whānau-centred initiative, working with offenders going through the criminal court, victims and their whānau. And we've had 833. We do whānau hui, we do support plans, and we've recently had going through some evaluation of that at the moment, and the early indications are that it's showing really good results because it's whānau driven, it's whānau initiative. But it does, our levers in the system are somewhat limited. We have to work with other agencies, we work with the judiciary.
So how do we get over that? Because that seems to be the key, is everybody working together. So we got it crystal clear from corrections that despite being more prepared than they have ever been before, they still can't achieve this on their own. So what needs to happen in order to get the cross-agency work programs thought out, rationalised against the available evidence and all of that, and then underway? What needs to happen to make that?
So what is happening? I mean, the program that Sheridan outlined, there are other similar sorts of programs that are quite deliberate about drawing the strengths of community and the strengths of different agencies into the problem. So there's a way, there's a range of these sorts of things. The whakaorangia e mana tangata is a particular version of that, but there's also the integrated support response, which is a process that wraps around care around family violence victims and tries to draw on the strengths of all different agencies. Part of the answer to this is actually how you work locally, right where the need is, and you see what is necessary locally, and you bring that support from around. That, I mean, you're right to highlight it as a thing the system has struggled with, because we do struggle with that. You know, we actually to get to the point where we're all working together means we've got to actually go out of our kind of our typical silos where a lot of our accountability lines run. But that's a recognised problem, and we're putting quite a lot of effort into it. In the family violence space, we have an interdepartmental executive board, Puna Aotearoa, and that is where we've quite formally brought a range of agencies together. We've fronted in front of this committee to talk as a collective of agencies, recognising that actually we've got to break down some of the barriers that go between agencies, some of the natural defaults that keep us in our silos, and identify how we work across them.
So just lastly then, between yourself, the Commissioner of Police and the CEO at Corrections.
Yeah.
Do you think it's within your guys' three capacity to make that happen?
Not just our three, no. What is in our capacity is to identify how we can integrate together and work our processes together. But the problems I'm talking about, actually, I do work with a lot of other chief executives. It's not just those two. It's MSD, it's health, it's housing, it's all of those ones, because it's actually, that's the broader group that you've got to try and bring together in order to really solve some of those problems. And it's hard.
Okay.
It's hard being in prison as well.
Absolutely.
I'm being
So we'll go Lawrence, and then we'll go to new line from Paolo, then Ginny, Lawrence, Todd. Supplementary, Lawrence?
You did.
Supplementary, otherwise
Okay.
we'll move on.
Thank you, Mr. Chair. You mentioned before court, and we know that having that equitable accessibility to court system is absolutely crucial in a lot of things that does happen afterwards. So what measures or what initiatives is the Ministry of Justice taking in collaboration with these other agencies that, you know, my colleague Tucker mentioned before, to make sure that court are more accessible for people with diverse background, mental health, disability, Māori, Pacifica, you know, women, from all of those perspectives, like what tangible steps?
Yeah.
Are we increasing the number of legal aids? You know, are we improving accessibility to courts? You know, are we having NZSR interpreters, for example? So we're really keen to hear from you on some of that move towards equitable access.
Well, in the court space, the question you've asked is actually how I would play what Te Ao Marama is one of the key objectives of Te Ao Marama. It is about ensuring that the people who come before the court, and that both includes those who are accused, but the victims and others there, that they feel that they are heard and that they are able to engage with the processes that they're experiencing. So that wraps up a lot of the things you identified. It does wrap up ensuring that people might have support around them. It wraps up specific guidance that the judges have put out for themselves in terms of how they engage around using much more plainer language. It does reflect on making sure that we're able to have interpreters and the like available. So there is a big body of work. We've recently done a legal needs survey, which has really gone to exactly the question that you've asked, and that did identify that different groups experience the justice system differently. Different groups have different levels of demand, and not surprisingly, within that, the groups that often struggle just generally in society and have the less positive statistics are also those that have the less positive statistics in terms of their access to justice. So whether that is disabled people, whether it is different ethnic minorities, and some of it actually talked at the small businesses versus big businesses. You know, there's a range of different sorts of needs that people have. So one of the things we do is at least try and understand that, and we put a bit of investment into trying to understand that picture better, because that frames the kind of overall work program that we can bring.
Okay, thank you. Paolo, new question.
Actually, the new question is morphed into a sub, but also with a new question. So it sort of ties up what has already been mentioned, that you are the lead agency in a sector-wide response, towards a sector-wide response. But looking at the 2023-24 annual report, it's not easy to see a measured outcome or a measurable outcome linking the funding, the activity, and the system outcomes that we want to see, and that would be good for this initiative of a joint sector-wide response to be visible, not just to ourselves but to the public. And I'd like to ask, and if you could speak, please, Andrew, to the plan to make it. We can see you're moving, but to make it a measurable and defined.
Yeah, and you're particularly talking about the things that impact across the whole sector.
Yes.
Well, I might invite Erin to come and join us at the table to see, because I'm sure there'll be opportunity for her to pitch in, given her role as the the executive director of the sector group that we have that supports all the agencies. But let me have a go first. As a group of Justice Sector Chief Executives, we're called the Justice Sector Leadership Board, and I chair that, but I also have Corrections, Police, Crown Law Office, Oranga Tamariki, and the Serious Fraud Office. We collaborate in slightly different ways on different issues, but our dominant work program over the last year has been around timeliness. Timeliness is a thing that presents in the court system, but it's actually it's dependent on how well police do their disclosure and how well they prepare at their side. It's dependent on whether the corrections reports are ready when it comes back for sentencing and on the different sorts of systems. Yes. Obviously, it impacts on the way Crown Law engages with the prosecutors and the like. And in that space, we've put a lot of effort into measurement, and over the last year, the Chief District Court Judge, with our support, but it's in his gift to do this, has put out essentially a standard that says here's the pace which we think it represents good justice for matters to make their way through the district court. And because every case is a little different, you don't have that as a 90% standard, you 100% standard. And he's basically said that you would expect 90% of cases to get through the court within these timeframes, and has put that as a target, which we are using now across the board. It shapes the work program of all of the agencies, and we have very regular meetings around those issues. So at the moment, we're tracking at 81% against that standard of 90. So it's very measurable, and we are reporting on it. And you can see that in information. We have modelled a range of interventions that we're doing and what we think will be the impact of those interventions as we go forward. Some of them have money attached to them. The Police Prosecutions Uplift Program is one such, where they're actually putting a lot more effort into ensuring their disclosure is ready, because that's one of the big bottlenecks often in the court system. But we've done a bunch of things inside the Ministry of Justice as well, in terms of how we run case management, in terms of how things function around the duty lawyer service and some of what they do. So there is money going into that. It's actually most of the money in my business goes into that work, and we do have measurable targets, and those targets are owned by the sector as a whole. If we look at,
can I very quickly interrupt? I'm sorry, Paolo. Those targets are owned by the as a whole. Where are they reported and measured against? Where is that found for us and for the public?
Yeah, we report against it in our statements of intent. We don't. What's our public reporting on that? Are we doing public reporting on that yet? We will be. That is one of the areas where we'll be looking at our performance standards. The new protocol's only been in place, I think, for 6 months, and so it's now what we're using. It is a protocol that will absolutely be public. I think it'll be one of those areas where I expect we will update some of the particular estimate, the measures that we have even in our estimates documentation, because it'll fit better there.
Yeah, thank you. Sorry, Paolo.
In relation to that timely access to justice protocol, which you mentioned in your introduction, and you're now saying that we are tracking about 80% of that target. Could you help us locate ourselves what the measure was and how we can say we're 80% of this target? Was that timeliness protocol? How do we see that timeliness protocol and the 80% tracking?
I would characterize our progress in this space as we were on a very steady deterioration in our timeliness, and that had been going on for a number of years. That problem was worse in Auckland than it was in other parts of the country. The big courts in Auckland were suffering from a particular form of churn. Their backlogs were going up, their timeliness was going south. Since we've brought the protocol, and we've been putting a lot of effort, particularly in the Auckland area, the broader Auckland space this year, and we've actually managed to turn around the Auckland numbers. If I can just, in fact, why don't you want to just swap out? Sorry, Mr. Chair, we will just have someone moving in and out of chairs. Tracy Bagley is the acting PU at the moment, the chief operating officer. But we've turned around the picture in Auckland. I'll get Tracy to talk a little bit more about that. At a national level, what that has had the effect of doing thus far has stopped the deterioration. And so and now as we model our way forward, we can see how the rising tide in Auckland, and we'll roll out some of the measures we've done in Auckland, will lift us towards the 90% target by 2027. But do you want to give us a little bit more of a boost on the numbers, Tracy?
Yes, Andrew. So I think as Andrew said, we have really started in Taranaki Makaurau purely because it's the largest area with the biggest backlogs, particularly since COVID. So what we're seeing there is obviously, although the national timeliness is 81, we've seen an increase in the timeliness from 71% to 73% in the Auckland area. So in terms of backlogs, we can actually look at, so the backlog of cases nationally has reduced by 6%. It's reduced by 22% in the Auckland area because we've had these initiatives in place. So you're looking at your same day sentencing, as Andrew's talked about, the duty lawyer operational pilot, the judge alone trial readiness. So these initiatives combined with corrections in police and of course the judiciary and we've put a lot of effort into training our staff and focusing on file preparation for court and those sorts of things to try and cut down on the adjournments in that space. So we really are starting to see the fruits of our labour in that area. Some of those initiatives we started to roll out now to the other areas. So Hamilton, the Wellington, Hutt Valley, those other areas. So we'll start to hopefully see the increases there.
This is such a good thing to hear, and I think it would be a good suggestion to have this in the reports much more enhanced and visible, because it's good news.
Yeah.
Yep.
Erin, is there anything you want to pitch into that from the sector perspective?
You've covered it.
I think I've covered it. Okay.
We'll go subs from Todd.
Yeah, I just want to make sure I'm that's great. I think I'm crystal clear. But what you're saying is this standard protocol you developed, but it's been adopted across all of the justice sector leadership team. Is that right?
Well, the protocol, so we're in the world of what are the judicial responsibility and what we do in support of that. So the protocol is owned by the Chief District Court Judge.
Yes, but you facilitated that. It's in place.
But he obviously consulted with us, and we supported him in the preparation for it. But that is a protocol that we are using as a sector. So we have the JSLB has a subgroup that has been meeting really every 2 to 3 weeks, to be honest, at the chief executive level, to put the effort into this. It's a big, complex system that is proven really hard to shift. And so we now have, you look at the big picture numbers and we've flattened the deterioration. You look at the leading indicators, particularly where we've been putting the effort in, and you have some confidence that we're actually bringing it out the other side in terms of performance of the system.
That's good. I just want to make sure I was crystal clear. I think we'll just, as my colleague said, I think this is something actually each of the agencies should have probably reported on, but it's okay. We're getting you all in February, but I think that's something.
March, don't scare
March,
them.
sorry. Because I do think this is, and to Mr. Ferris's point, this is where you actually need to see CEs and leaders working together on a joint, a joint target or a joint way of doing things, and then actually delivering that outcome. So,
that'll be a good conversation to have. You, in defence of all of us, as not having it in our estimates, the protocol itself has only been in place for about 6 months. So it was coming in really just at the end of the current reporting period. But telling the story, I mean, we're now publishing dashboards for each of the local justice areas, and then there are networks that involve the profession, the judiciary, all of the different agencies, and it enables them to be much more forensic at actually understanding what's going on in their area. A lot of these problems will be slightly different in different court areas, and it enables them to actually get better at trying to solve some of those problems in a location by location basis.
Thank you.
Target first supplementary, then.
Yes, supplementary. Thanks. Just picking up on this conversation, right? This conversation sounds to me like a bunch of CEs getting together, working out how to do something brilliantly, putting the actions in place, getting all the resources into it, hit and go, and 6 months later, there's a 2 to 3% increase in performance.
That's pretty accurate.
It's pretty accurate. Is that not applicable or applicable to reducing Māori overrepresentation and justice? Is that not a model for that?
There's a lot to commend that approach for all of the big problems we face. In a word, yes, there's a good way of working together. The difference, though, is that in the timeliness space we're talking about, that's stuff that we can actually much more directly influence is the reality, because between police, corrections, Crown Law with the Crown Prosecution Service and ourselves, working in an appropriate kind of respectful partnership with the judiciary, we've actually got a lot of the players that you need to be able to shift the dial. If you talk about some of the broader Māori outcomes, they have their origins in a much deeper, much more complicated and long-term set of issues. But that doesn't mean that the approach of actually getting different agencies together and saying, what do we bring to this problem, isn't a good approach. It's a good approach for all public policy problems that are cross-cutting and hard. And obviously some of the ones that you're flagging are absolutely in that camp.
Given the long-standing nature of this problem, would it not be irresponsible of us in 2024, considering everything we know, to not make this the number one priority?
Well, that's clearly you're posing a question that is more of a question of politicians than it is of public servants.
I'm just asking you as the CE of Justice.
Well, as CE of Justice, we highlight where we see issues that need to be resolved, and our job is to put that advice in front of ministers, and then we're guided by, to be honest, it's ministers that will set the primary priorities that we work on as agencies. We have some stewardship responsibilities to ensure that we are able to put advice up and help be an input into those decisions. But my responsibility is to support ministers in what they're trying to do, give them my best advice and our collectively best advice on the sorts of issues.
So just quickly then, your responsibility to society?
My responsibility, I'm a public servant. My responsibility is to serve the public of New Zealand, but I do that through supporting the government. And I do that in a range of ways. Sometimes it's by giving advice that says you might be making a mistake here. Sometimes it's by saying, here's the best way of implementing this issue. Sometimes it might be saying, have you thought of this? But, if I take us back to our purpose statement, how do I enhance people's trust in the law of Aotearoa New Zealand? It's by supporting the institutions of democratic government. And that has me doing our absolute best.
Well, when the democratic government and all of its institutions have failed to deliver justice for Māori, what then?
Well, I would highlight where I think we are doing poorly and make sure that's reflected in the advice we give to ministers.
Thank you. We'll go primary question from Jim.
Thank you. As the lead ministry now for firearms reform, I just have a few questions in that space. Police have consistently given advice that some of the reforms around phase 2 are a risk to public safety, and the advice from Justice has failed to reflect that police view in cabinet papers. Are you concerned that this could negatively reflect upon your ministry and the quality of the advice that's being provided to cabinet?
No, I'm not concerned about the quality of our advice that's gone to cabinet on that.
Why not? If that public safety advice is failing to reach.
We've obviously reflected the feedback we've got from other agencies. We've put our advice up to ministers. We then produced cabinet papers for ministers. Cabinet papers obviously the ministers own what goes into a cabinet paper. Our RISs will put our perspective into that space. Our RISs reflect the advice that we've received and the best views that we have.
But the briefing paper I have seen is that police provided advice, public safety advice, that was not captured or reflected in that cabinet paper. And the reason given was it was the too short a time frame, so police advice was not included. In terms of the specifics of that, I'm not over exactly that interaction that might have occurred between police and ourselves. What we have done is talked with police, and we have across the board, we will have incorporated their advice into our advice that we've put in front of the ministers. Minister made decisions. You'll see our advice in the RISs that we've prepared as well.
So just pause one second, just a process issue. We just need to get permission for your staff to take photos in the room. So just
Sure.
leave the committee for permission to happen, and just to retrospectively.
Only my good side though.
And just to retrospectively apply that as well. Everyone's fine with that?
Yeah.
Okay.
So the cabinet paper on phase 2 did not have police advice in it, which specifically said there were public safety risks. Why was that?
In terms of the specific interactions that might have occurred around that and whether there were timing issues.
I'm not
or the like.
concerned about the interactions. I'm talking about the cabinet paper that went to cabinet on phase 2 firearm reforms had no comment from police on public safety risks of deregulating firearms ranges, even though they had consistently raised this with your officials and wanted their advice reflected in the cabinet paper.
I would have to come back to you with an answer if there was a specific question about advice that wasn't incorporated into cabinet paper. Typically, we will reflect the advice we get from agencies. In fact, our best practice would always be to make sure ministers were aware of that. If agencies want to put advice into cabinet papers, there's generally an opportunity for them to do that. Ministers own the cabinet papers, but I think we reflected quite a lot of that advice, and certainly our advice, and I think in the cabinet. But I'm actually, there's a specificity about your question that I'd need to come back on, I think, in terms of the specifics of it.
Police have stated that the lack of regulation on the proposed gun range bill has real potential to undermine public trust and confidence. Are you concerned about that erosion of public trust and confidence? And if so, why was that not highlighted in the cabinet paper?
Well, Ian, I think in our advice to ministers, we have reflected the concerns that have been raised with us. And I mean, said I'm happy to come back to you with exactly what advice went up around the cabinet paper itself. The criteria cabinet has set for the firearms work, public safety is the top of it, and then you're looking at the impact on clubs and ranges, and you go through a series of things. There's obviously several phases to that work. There's a broader review of the Firearms Act that is still to come, and that there's opportunity to pick up all these different sorts of issues in that. There was some short-run issues that were clearly part of the 100 days plan and cabinet commitments to get coalition commitments to get underway with some of the changes to Part 6. And there was some time urgency brought to us around that because of impacts on clubs and ranges as they were going through that process.
I was specifically talking about the legislation that's now just getting ready to be reported back, so that second bill, and it states that due to simultaneous agency ministerial consultation, the draft cabinet paper and consultation document forwarded to ministers for feedback do not take into account New Zealand Police's feedback and concerns. And they state that police still considers the paper does not clearly outline the public safety risks associated with proposals to reduce obligations on shooting clubs and target shooting range operators. Are you comfortable with the fact that public safety advice from New Zealand Police was not included in a cabinet paper when ministers are making decisions about deregulating gun ranges?
Well, as I say, I'd have to come back to you on the specifics of what happened with any submissions police made to that process. Where police have brought advice to us, we have reflected that advice in our advice that we've given to the minister.
Have you as Chief Executive considered intervening to defend the integrity and reputation of your ministry when regulatory impact statements plainly say that proposals have not been rigorously tested and are largely based upon the life experiences of the minister?
Well, the truth is, across the board, when you have new governments come in and they bring a level of urgency, there are some trade-offs made as to how much consultation and how much engagement occurs. We've had that discussion with ministers. We've set that out. We're very clear, therefore, sometimes where we think the limitations of our advice are that they may have only gone so far to incorporating things. That's a perfectly legitimate thing for ministers to do, to say is that we're on a timetable here, and as long as that, I think, is explicit, that's a trade-off for ministers to make.
Are you comfortable with those trade-offs and that they don't negatively reflect upon the integrity of the advice provided?
I think the advice provided is we're clear to ministers what we think the trade-offs are and the timeframes around that. So I'm very comfortable with the advice that we've given on that space. Some of it has been advice in a time that's constrained by the pressures of timing.
Did the minister discourage officials from giving free and frank advice or including that in advice provided?
No, we've not been discouraged by giving free and frank advice to ministers. In fact, I would say all the ministers I've worked with at the moment, we've had some very robust conversations. We've given very free and frank advice on matters.
Did the minister request for the Police Association to be excluded from consultation on phase 2 of firearm reforms?
I think we certainly had a list of people to consult with. We consulted with the police, and I think the judgment was made that we had the perspectives from police that we needed on that.
So was that a decision from the ministry or the minister to exclude the Police Association from consultation?
My recollection is that was a decision by the minister with a list of parties to consult on. But the view was that we were getting consultation from police and that there would be other opportunities and subsequent opportunities to engage with the Police Association and other stakeholders. So it was you're clearly making decisions on who you consult with at what time to move things through to ensure that you get a decent coverage of things.
The New Zealand Police Shooting Range Manual is essentially like a road code for rangers. How will the lack of a nationally agreed standard for gun ranges impact the ability of government to ensure that there is independent oversight of gun ranges?
I think that the issues in the gun ranges space, it's getting a balance of what is the kind of broad safety framework that you need and what is the level of compliance cost that goes alongside that. And I think there's a legitimate set of things to trade off in there. What we've looked to do in our advice is make sure that those trade-offs are as visible as they can be, and that's what we've sought feedback from the parties that were consulted with about that.
So if governing bodies for shooting disciplines set their own standards, which is what this legislation does, what happens if something goes wrong or if there is an injury or a death?
There's a level of detail in some of the questions here that we might need to come back to you on, or that might actually be better traversed when the legislation has been considered by the committee in this space.
But you are aware that the legislation provides that rangers will essentially set their own standards.
Well, I think in any of these sorts of regulatory things, you've got to be making judgments about what do you need to set nationally, what might you put in primary and in secondary legislation, and what might you invite individuals to specify themselves, and then against that, what sort of transparency would you put around that? There's a very legitimate set of things that you would want to consider when you're working out what is the optimal regulatory structure here that balances public safety and compliance burdens and the ability to get cost and all of those sorts of things put together. And the detailed bits of that argument, I think there'll be other ways of pulling that apart, and this committee will have plenty of opportunity on that, I would have thought.
Yeah,
Do you know?
we can keep going.
I have one more.
Yeah, we can keep going. We may be running out of the ability to make much more progress given that the legislation is still before the committee and is yet to pass. So,
has the Ministry of Justice completed the firearms registry review?
I think we have that in a near final draft form.
Has the Minister reviewed that yet?
Pardon?
Has the Minister reviewed it?
I don't know if the Minister's, I don't think she's concluded her reviewing of it at this point.
So it's still with her presently?
I think it is, yeah.
She's provided no feedback on that?
Do you know whether...
I don't think we've had feedback on it. We can come back and check. But
that would be good to know.
Yeah,
and last question, how many changes to firearm regulations were passed by Audit and Council in the past fiscal year?
I'd have to come back to you on the specifics of that.
Right.
I have a supplementary.
Starts from Todd, and then we're going to go
Just
to
on,
primary from Lauren.
Jenny Anderson's total overall bunch of questions. Are you, as the secretary and the whole ministry, operating a fairly standard way, advising the current government as you would have the last government?
Yeah, absolutely.
Thank you.
Okay, we've got primary now from Lawrence Shunan.
Thank you, Mr. Chair. I asked the question before in terms of some of the earlier stages when people enter into the system, but now I want to kind of ask sort of the other end, which is when we're looking at something has happened, both in terms of rehabilitation, but also in terms of victim support, because they kind of go hand in hand. So if we're starting with rehabilitative programs, what have you seen that has been really successful in terms of rehabilitation and allowing people to, I guess, be reintegrated and rehabilitate and going back to the community and not reoffending? And the reason I ask this is because, when we're hearing it from let's say, some of the prison whānau themselves, let's say, the Te Marama unit, Pakaria, that's not been happening. They're not getting the wraparound support, both from a financial perspective, but also from counseling and also job security perspective.
That's probably more a question for my colleague, Jeremy Lightfoot, who you might have spoken to today, because a lot of those rehabilitation programs will be managed through corrections. The one place I might be able to add some insight really goes to te mana, te whakarongia te mana tangata program that Sheridan mentioned earlier, where we do facilitate through the court an opportunity for some of that wraparound support to happen, and that may then have an impact on what actually happens to those individuals, the support they get, and that may shape the sentencing and the rehabilitation opportunities that they get. Most of the sorts of issues you're raising, though, I think are actually when it's moved beyond the court world and more into the corrections space.
Yeah, but in terms of corrections, the issue that we're seeing is that through a lack of, possibly at this stage, what appears to be a lack of support, they are re-entering into that court system. So we are seeing sort of that vicious cycle. And for some of them, they have said that we don't have anywhere else to go. We see prison as sort of a place of familiarity because of the fact we don't think that society wants us here.
Well,
so they're entering that. So how, I guess, through the program that you're talking about, and as Minister of Justice with the overarching, through some of the programs you're looking at, how are you working with the other agencies to break that vicious cycle? Because I think, some of the things we're seeing in terms of 3 strike legislations and all of those simply, actually encouraging some of these behaviors potentially. But I'm more interested in breaking that cycle.
Well, probably you would have had more of this conversation, I think, with my colleague, Mr. Lightfoot. From the sector point of view, what we would try and bring is, does the overall picture here look like it's got all that we need in it? And so the discussions we might have as a sector would be, how is corrections reviewing the work that they have? And I know they've gone through a process of making sure that they keep backing those programs that are most likely to be successful. But again, the detail of that would be not something that as Secretary for Justice I would have close insight on. I agree with your overall proposition. We should be interested in rehabilitation. We should be interested in making sure we put the support around people as they go through the criminal justice system. We have some opportunities to do that in court, which is by making sure that you have some of the supports around people as they're going through, whether it's victims or perpetrators, and that you can refer off to the right sorts of places. But more of that activity actually will happen post-sentencing, and at that point it becomes more of an issue for corrections.
And I guess shifting to sort of some of the victim perspective, we've heard it from police as well, but also from, I guess, again, an overarching perspective, alongside Te Marama, what is being done to ensure that victims of crime are also supported in a way that is potentially, let's say, culturally appropriate. And we're looking at Māori, Pacifica, ethnic communities, rainbow, disabled communities, etc.
Yeah, so again, I might invite Erin to join us at the table. The victims are one of those issues that we really have to think about as a sector, as a whole. So as with timeliness, so with the experience of victims. It begins with the police, it carries through the experience that people have in the court system, and it actually can go to when someone might be sentenced, when might release occur and the like. So the part of the discussion we've had at Justice Sector Leadership Board is what are the ways we can put support around that. In the justice space, we put effort into victims support and into grants. We have our court victims advisors that actually work with people, and they've increased the number of victims that they work with to help them understand the court system as they go through it. But Erin, do you want to talk a little bit about the way the sector is thinking about victims?
Yeah, sure. So victims, as Andrew says, is another one of those complex cross-sector wicked problems for which no one agency has the levers or the solutions on their own. And it's something that Justice Sector Leadership Board and agencies have been working on together. Under the previous government, we did a lot of work to understand what the current state is and where the problems are. And from that work, we have, under the current government, identified 6 areas where we think that there's an opportunity to do better. We're just starting to implement some of those things now. They are across the board. So there's something in the parole board space around making sure that victims are notified better. There's something in the victim impact statement space about making sure that victims' voices are heard appropriately. We've got some particular focus in the young offender space. One, supporting victims of sexual crime better, and one, supporting victims of youth crime better. And we've increased some grants as well. We have a behavioural science capability in our little team that supports all of this work and understanding all of the different needs of victims, who's overrepresented, how we meet all victims where they're at is part of what we do and what we're working on.
One last supplementary question, Chair. That sounds a lot of the initiatives sounds really good, but I want to pick it up from when all of these ideas and plans are being conceived, when we're looking at a decision-making table in the Ministry of Justice, and I'm looking at Ministry of Justice ethnicity, background, and breakdown. There are 13% of Asian staff within this, 0% for tier 1 to 3 managers, 0. So how are you going to ensure that, for example, the voice of ethnic communities and Asian communities are at that decision-making table, so what you are currently putting through is appropriate for our communities?
Yeah, those statistics, which I think related to 30 June this year, weren't quite accurate in our place because we had a DebSec at that point, Rajesh Chana, who was Indian, and so we did obviously have Asian representation at that level. But the point you raise is nevertheless a good one. How do we ensure that we are able to represent New Zealand, and that we have some experience? And we are light on representation of Asian people in our senior ranks. I acknowledge that. You've just, I think, in the absence of having made appointments into that space, and you should be, it's always, you take into account a lot of things when you make appointments, but I think we need to be mindful of some of those gaps and be quite deliberate about it as we're preparing policy and preparing any decisions that we make, and then look for ways of compensating. And so that could be that you actually go out and talk to different representative groups to try and bring some of that perspective back in.
I'm going to take this up from Tracy. We're in the second half of the hearing. I'll just note that there's 21 minutes, 50 government side, and 30 minutes, 20 on the opposition side. So Tracy, and then we'll move to the next sub.
Okay, thank you. And it's probably quite a quick one. It's just that I appreciate the fact that you've done a lot of talking today about not working in silos. And as has been previously said, one of the frustrations I find is that we don't have there's not a lot of transparency about how you do work together. So, for instance, it's very easy for us to ask a question of corrections and then to give a high-level answer about something that happens in a joint justice-y sort of type environment. But we struggle to have any clear sight over that, and it runs the risk of different aspects of the justice sector sort of passing the question or patting the question over, and no one actually answering it. How do you think, and that may be a factor of the recency of working together in the way that you do, but is there any plans, do you recognise that as a potential problem? Is there any plans to mitigate that? And how do we know where to look if it was to improve?
Well, I think the way I experience that issue is a lot of what we're working on, we can only make an impact on if actually we get a whole lot of different agencies working together in a coordinated way. And so that's why we do set up a bunch of structures to do that. It's why in the timeliness space we've got a meeting every 2 to 3 weeks. It's why I bring together the broader JSLB. We now have a formal board meeting on about a quarterly basis, given we're meeting so regularly on other matters. In the family violence space, we have the Interdepartmental Executive Board, which has to report, and which this committee has interrogated earlier in the year. But I think to address exactly the sorts of issues you're raising, that all of these things, we all have a little bit of them, and some of the problems that we're talking about are actually a function of the combined effort, and sometimes, to be honest, the combined failure of a range of different agencies. So that is it's an enduring public management, public policy problem. We're actually really aware of that and do spend a lot of time together across agencies to try and actually grip up the things that we need to grip up collectively.
Great, just Hilda. Me following up on Erin's points, the 6 victims related measures or programs or initiatives. 3 things: are they being measured or will they be measured? If so, by who? And if so, how will that be reported?
Yes, the measurement's been worked on at the moment, and when we come to see you in March, I'll give you an update.
Very good. Primary question.
Oh, yes. Just turning to your annual report, I just want to actually talk about the improving access and experienced participants in courts and tribunals. So that's one of your priorities. Obviously, I suppose the backlog of court cases remains probably not where you would like. It seems still pretty difficult, and there's still a large backlog. So I'm keen, one, to kind of understand exactly what are the key challenges in getting this backlog reduced, and how are you addressing it? The one bright spot does appear to be the coronial system. So
Yes.
again, I want you to understand. So tell me about the overall problem around the court backlog, but then the coronial system, and there seems to be improvements are made there. And is there anything you can learn from what was done there, transfer it across?
Indeed, and thank you for the question. So the good news is backlogs this year have reduced by 6%, and that's a continuation over the last 3 years. That's in the criminal jurisdiction. We've talked a bit about the sorts of things we do to deal with the timeliness and backlogs. As an aside, there's a challenge in here in what you measure, because the new protocol says you need to get, it's actually set out what the time frame expectations are for each phase of a file, and then what it should be disposed of. Backlog is how many cases essentially are over the older limit of that. So you can see that in a way, if you're not careful, these statistics will pull against each other, because once something's made it into backlog, it's already been counted against the timeliness standard. So we measure both. We're looking at how we're doing against the 90% target that the Chief District Court Judge has given us, and we're measuring backlogs. And as I've talked previously about what's happened on the timeliness space, we've arrested the decline. We have turned the corner in Auckland, which has been actually the biggest drag on timeliness, and we can see our way towards getting that back up towards 90% over the next couple of years. Backlogs is, at the same time as that, we've been putting a lot of effort in to try and reduce the backlogs, and those numbers have come down consistently over the last 3 years, and we're making good progress. Again, that's been sharper in Auckland, but it's happening across the country. I might talk criminal first, and then perhaps come to the coroners briefly a little bit after that, and I'll get Tracy to pitch in, and possibly Erin as well, on the criminal space. There is a whole lot of things that we're doing. If we've done the analysis that says what do we think is actually driving the deterioration in timeliness. It's that we've been having more adjournments. It's that more people are electing jury trials, which take longer and drag you into the system longer. And it's been people have been pleading guilty later in the system. So if you dig under those and you say what's driving some of those things, and they're complex and there's a lot of things into them. But one of the issues was police disclosure. So we've worked really closely with police. Police have brought in a new model of how they do their disclosure, and that is, we think, making a really big impact across the board. There have certainly been issues around, as Tracy talked about earlier, in case preparation and the way some of that work has gone. There's been work around scheduling, and we've scheduled differently now. We had a system previously where if we weren't able to see our way to a particular schedule for a file, we would give it a nominal date, which in a way is like just putting it off. And the system became a little bit addicted to that, because it became a kind of an endless set of adjournments. We've now got to the space where I think in all but one court now, we have a limited scheduling to nominal dates. So the date might be up to 12 months off, but you'll get a date now, and that means that the system can actually plan with much more confidence in that space. The Chief District Court judge has put out a bail protocol, which means that it's forcing people to be much more ready by a particular time, and then for the whole system. Often that's about corrections activity and the like to be wrapping around with that. We've done. So I might hand over to Tracy in the first instance. We've done more work in the duty lawyer space and in the way we work at the beginning of the system as well. So, do you want to talk about that?
Yeah, absolutely. So. And just to clarify, as we've said before, it's really important that all of these sector partners are working together on this. And so the duty lawyer operational policy has really been about ensuring that an urgent assignment can be made on the day. So this is all about making every event more meaningful, obviously. So rather than just coming in front of court for your first appearance and then it being adjourned off, it's actually about going, what can we actually do on the day? So the duty lawyer operational policy is actually crucial to having the additional uplift in the police prosecution. So we've got additional prosecutors in court, which means that defence counsel can have, can have a good conversation with the police prosecutors. So they've got more to have a conversation with the client on, essentially. And then a decision will be made then as to how the client wants to proceed on the day. So the duty lawyer operational policy is actually ensuring that the duty lawyer on the day can actually progress that there and then. And if they can't, for whatever reason, progress that, then we're facilitating an urgent assignment to counsel, which means that counsel can be there within 20 minutes down to the court to actually progress that matter on the day. Now, previously that would have been adjourned and then possibly adjourned again until the person had the opportunity to meet with counsel, of course. So that's been a real big shift change. But again, to Andrew's point, it's really important that we've had that uplift in the police prosecution. Feedback from the profession has been really positive on this, that they're actually using the prosecutors in courts, not just for those first appearances, for other things, which is making a difference, having those conversations. And it's the quality of the information that they're getting to be able to discuss with the client.
Great.
Erin, do you want to, because again, from the broader sector point of view, I mean, things you would pitch in addition to that?
I'd reinforce what's already been said. I mean, prosecution's a really key part of it. This is the first time in my 20-something-ish years in this space that I've seen the judiciary, the prosecution service, the legal aid, everyone lined up and peddling their waka in the same direction. So those early indications, I think, are an indication that we have turned the corner, and I'm quite excited about what we'll see in the next 12 months.
It would be remiss of me not to acknowledge the judicial leadership in this space as well, because clearly, there is a partnership here. We agencies of the executive and all the levers we might be able to control have to work within a framework that the judiciary are working with, and that's been really positive as well. Briefly on the coronial space, so we are really pleased with the progress we've made here. It used to be a consistent feature of me fronting up to this committee and its previous guises that the coronial jurisdiction would come in for quite a lot of criticism. And that wasn't for want of trying. These systems are difficult and long and hard to turn around. We've in the coronial space, it's been a bit of a full court press. We have put more resource into it, coronial resource and clinical advisors, but we actually we started turning the corner, getting improvement before all of those newer resources sort of arrived. And we did that by just trying to break down and systematize much more the way we support individual coroners. So it was as simple as things as bringing better defaults up in terms of letters and reports. So we looked at all of the different parts of the process and asked, how can we support the coroners in their decision making? The chief coroner was, she's been really committed to actually getting better progress, and so she's worked with the coronial bench in terms of helping them learn from each other in terms of the way that they progress matters. And then we have brought more resource in as well. So the resources, I think, helping us, it's prolonged the improvement and will help us, I think, kind of carry it into the future. But I'm very proud of how the system has functioned in the coronial space.
Great, thank you. All done on that line. We'll go to Duncan Webb
Thanks for that. I just want to talk a little bit about some appointment processes that have been in the public eye. And I'm aware that obviously the ministerial decisions are in there, but I'm just interested in what goes on internally. So, for example, in terms of the Human Rights Commission, were those appointments widely advertised?
Human Rights Commission, I think it was certainly, we advertised, we called for nominations, a range of different names and people came into the process.
I had a look at the Public Service Commission's kind of guidelines, which do talk about making sure you get broad reach. Do you know what was done exactly or not?
Well, we would have certainly put it out. There would have been opportunity for expressions of interest, and it was clear. It was talked about that we were recruiting, so there was opportunity for people to put their hand up in that space.
I mean, one of the things that strikes me is that in respect of the Human Rights Commission, the ministry has actually got a quite comprehensive document as to the appointments process, including reference to the Paris Principles, which are pretty important. Did you provide advice to the minister around the Paris Principles and the need for political neutrality?
Yes.
And so that would have included advice that the role was an apolitical one.
Certainly that would have been clear, I'm sure.
And the ministry guidelines talk about I don't know, what are the words? I'll get the words right. That the minister should consider consulting other parliamentary parties on appointments. Was that advice given to him?
I think all of, whether that specific advice was in the correspondence, I can't precisely remember, but absolutely we would follow a good process that would have put to the minister the options for how to seek expressions of interest and taken it from there.
So, I mean, the Human Rights Commission's a Crown entity, which says that the minister can only make an appointment if he is of the opinion that the appointee has the skills required by the legislation. And given that, in respect of the Chief Human Rights Commissioner, did you advise him, well, the facts are clear that he was given advice that the appointee did not meet the standard, was not a viable candidate. Did you advise him that that could be a breach of the Crown Entities Act?
But we wouldn't have said it would be a breach of the Crown Entities Act, because I don't think we thought that it was a breach of the Crown Entities Act. We gave advice to the minister in relation to how the attributes of the candidate, which were absolutely strong. They ticked a lot of the boxes, and the minister had a series of options to how he weighed all of that up.
Well, the candidate that was ultimately appointed was assessed by an appointments panel as not a viable appointment. That seemed directly contrary to the provisions of the Crown Entities Act, which in Section 9 says a minister must be of the opinion that the person meets the statutory requirements in terms of qualifications and experience. Did you give advice around the Crown Entities Act?
We certainly gave advice in relation to those appointments as to the sorts of choices that the minister could make. Okay,
but you didn't indicate to him that he was constrained by law in any way?
We absolutely set out the law and the options and the discretions that he had.
Do you consider that it was one of his options was to appoint a candidate who was assessed independently as not having the required qualifications?
I think the minister, it's still a minister's appointment. The minister takes into account the advice of a panel, and then the minister makes his decision. That's what happened.
All right. In respect to the Criminal Cases Review Commission, were those appointments that have been made advertised?
Again, whether they were advertised, I'd actually have to confirm one way or another as to whether they were advertised on that front. But again, there was expressions of interest. People were sought out, names were looked for in a way that is not.
So there was a kind of a search undertaken for appropriate candidates.
Yes, and I think it was advertised, is my memory, but I just have to confirm that to you.
How many candidates were interviewed for that? Do you know?
It's often not an interview process that you run in that. It is the people that tend to be reasonable candidates for that job are well known and understood as to who they are.
So would it be fair to?
It's different. It's different than a job interview in an agency. A lot of Crown
Well,
interviews.
Human Rights Commission ran
There's a
long
process
list
set
of
out in the
interviews.
Human Rights Commission. That's not the same process that you would do in all Crown interview
Okay,
appointments.
so it might be accurate that no candidates were interviewed.
Yeah, I don't think we had interviews as such in a formal sense.
Okay.
The conversations were had, but interviews were not.
So in terms of the Section 9 of the Criminal Cases Review Commission Act sets out what's required, and it requires a proportion of people to have tikanga experience and a proportion to have experience in criminal justice. Of the candidates, do you know how many were considered to have expertise in tikanga?
I don't have that information in front of me at the moment.
Okay. Well, I mean, obviously the Chief Commissioner appointment was an experienced judge, so he's had experience. Of the other two, are you aware that neither of them had tikanga experience or criminal justice experience?
Well, you've got to have a look at the existing appointees as well.
Yep,
so
I've done that. So there you've got two sociologists, one person with considerable criminal experience and the chair. So you're supposed to have 2/3 with criminal justice experience. And you've got, at the moment, it looks like you've got 2 of 8 with criminal justice experience. What kind of, did you advise the minister that the appointees did not have the experience required under the Act to give the right balance?
Look, in terms of exactly what advice was given in relation to the balance of them, I'd have to come back to you on the detail of that. But certainly we gave advice to the minister about a range of candidates.
Was the advice given to the minister that any of these appointees were not suitable candidates for appointment?
I don't believe so.
Are you aware of any conflicts of interest of those people who were appointed?
I'm certainly aware there are people, we all have conflicts of interest of one form or other. I think there are some there that are being actively managed, and I think that's
so that the conflicts, I mean, I think there's a relationship with the Crown Prosecutor of one of them. Are you aware of that one?
I am aware of that one.
And is there an active conflict of interest management plan?
Those are the issues that are addressed within and around the board of the Criminal Cases Review Commission, and those, I think, are things that are being managed.
Okay. Right, I'll leave that there actually, because I see my colleague Connor's arrived, and he'll have some questions later that he wants to make.
Very good. We're going to go to new primary from Jamie Arbuckle. Then we're going to, I do have in order Lawrence, Paolo and Takata, because Takata hasn't asked a primary yet. I'll go to Takata, then Lawrence, then Paolo. But Greg, if you have one as well, please pipe up. Jamie Arbuckle.
Thank you, Andrew. The Ministry of Justice, I'm going to take you to something quite different. I'm going to take you to infrastructure.
Yes.
And I'm going to take you to looking at the courts around the country. The committee here has visited the Supreme Court across the road. There's a probably world-leading example. We've been to Christchurch and seeing the Justice Precinct there. My question is what plan have we got? And I understand the ministry's put together a plan going forward. So first we've got to get on top of maintenance issues and then what that looks like in, say, 10 years and 20 years' time. So could you start talking us through that a little bit?
I'll ask Kelvin to reflect a bit further on this as well. But we do have a plan. We've put a lot of work into our property program over the last few years, and to be honest, we probably have the biggest property program underway now that we have ever had. We have a 30-year plan. We've broken down what we think the needs are in each court. It takes into account health and safety issues, seismic issues, operational sort of effectiveness, and the capacity and the capacity that might be needed, so sort of fitness for purpose. We do ratings on the back of that, and we then make judgments and assessments about where we have to invest. So that's the broad picture. Underneath that, there's an ongoing kind of maintenance and the like that carries forward. So we do have a big plan, and we're following through on it. And there's quite a number of courts that have been busily worked on at the moment. I don't know. You might get
That would be useful just to hear of some of the developments that are happening currently.
Okay, well, why don't you have a run through some of them, Kelvin?
Sure, thank you. Our current building program touches over 40% of all court rooms in New Zealand. Just to give you a bit of a scale of what we're working on. So we've got seismic projects underway at the Auckland District Court alongside upgrading the services in that building, so the HVAC and other systems in that building. We've got seismic work happening at the Hamilton District Court, the Wellington District Court, and another. Then we've got major builds which have been announced for Papakura and Wanganui. We're also working on a business case for a new build for Tauranga. And then we are in the process of an expansion in the Manukau District Court as well. So that's some examples of the large projects that we have underway at the moment. And as Andrew said, we've got a 30-year program, which is looking at how we continue to upgrade and develop all of our facilities to a common standard. Our initial focus has been very much on what we call the health and safety of our courthouses, so those where they're leaking and there's mould and that sort of thing. We've also got, I guess, a next tier of developments we'd like to get into, which is building capacity, where we've got growing populations, so increasing capacity in some areas as well, which will come further down the track.
Yeah, and just probably the key supplementary is there is concern, I guess, across New Zealand and regions and in smaller areas that courthouses may disappear, what will mean people having to travel distances. What assurance could you give that those courthouses are safe and they will stay in our regions as we know it now?
Well, we're always assessing need, and we're assessing what the options are in different places, and we're assessing how much, what the cost structure of some of those different sorts of things in. So we have one local court in Ohakune that is closed at the moment, but there are not specific plans elsewhere to close any other courts. But the reality is, as we go into the future, we'll be looking at how does technology play, what sort of role, what are other ways, are there other facilities? So it is a dynamic picture.
Thank you. I'll lead up with
Jamie, start from Cameron and then Lawrence.
Without the risk of getting too parochial, the Waitakere District Court rebuild relocation, is there a budget line item there? Is it in a plan? Is it in a vision? Is there any timeline around a business case or delivery?
So it's certainly in our 30-year plan, and it is one of those ones that we know where the need is relatively urgent. We have bought land in Waitakere in order to enable that development. It's one of the ones that we're having discussions with ministers about. So we're not past the point of, I mean, I can't give you a statement of timing.
You're saying it would be unlikely to happen.
I'll withdraw any specific comment on it.
Okay, but it's certainly not as advanced as those other ones that you.
No, it's not as advanced as those other ones.
Thank you. Okay, we're Lawrence on courts infrastructure.
Yes, actually, I was going to say that you mentioned Ohakune already, and this is something that was really key to actually Suits. What is happening with the Ohakune court?
Well, so the actual building there is not fit for purpose in its current space. And so that we have been looking at that. We are looking at alternatives to that building, including, I think it's Ngāti there, as to whether there are other facilities that we might be able to use in that place. At the moment, people are mainly going to Taihape rather than in Ohakune.
Which creates accessibility issues itself. But do you have a timeline for, some sort of timeline for that?
Do we have a specific timeline on that?
Okay. How we're working on it
Yeah,
at the moment. So.
No, in terms of finally resolving that, I would say that the costs of rebuilding the court there are quite hard to justify in light of the amount of use that it was getting in that space. So we're more looking for alternatives to a bespoke justice facility there than the court that we've had there.
Thank you. Thank you. We'll go to a new question for Takata, and then we're going to go to Greg, and then we'll go.
Kia ora, Hey, I'm just going to go to the treaty bill. And, just for context, there've been some pretty scathing reports from the Waitangi Tribunal, primarily around the accuracy of the proposed bill. There's been endless legal commentary undermining the structure and accuracy of the bill. 40-odd King's Council lawyers have advised the government against pursuing it, and even your own ministry has provided counter advice. So my question is really to your ministry and is asking, what's the responsibility of your ministry as the ministry responsible for this bill in protecting what the public are exposed to? Okay, so let me just, I want to rephrase it for you. I'm asking what just the Ministry of Justice's role is and your responsibility is in ensuring government treaty proposals, such as the Treaty Principles Bill, are at least as a minimum, accurate and congruent with the current body of evidence.
Well, if you haven't read our advice, and you probably have based on your question, you'll know what our views are on the Treaty Principles Bill, and we've given that advice to the Associate Minister. The Associate Minister gave us a very fair hearing in that and made decisions which the Cabinet has made, and the bill is where the bill is. So our responsibilities are to provide our best advice and then support the decisions that the government takes.
So given that your underlying ethos is improved trust in the law of Aotearoa, how does that then translate into you being a protector of the accuracy of information? Because there is a very accurate and agreed body of information available. And so how are we protecting the public from being exposed to perceptions that are ultimately unhelpful?
Well, our role there is to give our free and frank advice to ministers that, in this case, we've also testified before the Waitangi Tribunal. Our advice we've given has been available. But it's also my role in terms of ensuring trust in the law is that I support democratic institutions and I support the decisions that the Cabinet has made, and that's what we're doing. We are supporting the Minister with the Select Committee as the bill progresses through the House, and we will do that in a professional way.
So given then that the Treaty Principles Bill triggered easily the largest celebration hikoi the country has ever seen, how do we then provide that huge part of the democracy with some form of guarantee that they're not being misled or misinformed or even exposed to information or ideas that are ultimately undermining social cohesion, clarity, the level of expectation amongst cohorts of the community, all of those things. How are we protecting that?
Well, guarantees are not in my gift. What is in my gift is giving advice that is our best advice and that is clear, and putting that in front of ministers, and as has happened in this case, it's having that advice interrogated by the Waitangi Tribunal and being very upfront and candid in that forum, and it's been published as well. So that's how I play my part in this process. It's by giving our best advice and supporting the government with the decisions that it takes.
Kia ora, kapa. Thank you.
Folks. I'm going to go to a primary from Greg O'Connor. I have on the list Lawrence, then Paolo. Just so people know, there's 13 minutes 50 left on this side, 7.5 on the other side. I'll let people do the maths themselves as to what's left. We'll go to Greg, and if there's enough time for Lawrence, Greg O'Connor.
Oh, look, thank you very much. And I was just hoping to have some questions on courts, but I understand there's already been some discussion on court delays. One aspect that become apparent is court security, and with the need to absorb the 6.5% cost reductions there, manifested itself in, firstly, money not for travel, which has impacted on some of the remote courts that we've talked about before, and the ability to move security around. And secondly, and as a question, has there been an increase in the number of, shall we say, human resource issues within that workforce?
Well, let me give you an overview in that space. But the first point I would make is that the 6.5%, those, we did not take that out of the court security workforce. You know, we've looked at our national office functions. We've looked at how we've worked together in the national office space, but we didn't take it out of the frontline resources, including on court security. In fact, we have been increasing our numbers of court security. So that, I hope, is of some reassurance to you. We have a model that we have worked up that helps us guide where we deploy that security workforce. It takes into account risk. It takes into account practicalities of operating a court. But that is an area that, you know, we absolutely take seriously in terms of ensuring and investing in the safety of that. When I arrived in the ministry about almost 6 years ago now, we had, I think, in the order of 150, 160 court security officers. We're getting up in the high 300s now, and that has been an area, and that we've continued to invest. That's because the courts have become a more dangerous space, to be honest. We've got more incidents occurring in the court space, and you know, I think if you went to the profession now, they would say they were more apprehensive and concerned than they have been previously. So we've got a program that includes induction for all those who participate in the court spaces, obviously training type issues. We are, whenever an incident does occur, we are looking at what we have to do, what we can learn from it. That's led to a minor works investment program around docks and around the public areas, where we've actually been accelerating some of the investment to make our facilities safer, in that space. So the court safety is an area of real concentration for us, and something we absolutely taken seriously. Either of my colleagues could pitch in further on that if there's something you think I haven't mentioned that I should.
I don't think so, Andrew, except just to say that, you know, there's lots of training that have been invested in the actual court security, and, you know, court security are still able to travel where necessary to go to the courts where they're needed.
So what's about the travel?
The court security officers are still able to travel to the necessary court where security is needed.
Yeah. So in terms of, we have reduced our travel budget, we haven't done it for court security officers.
So the budget hasn't reduced. There's been no reduction in the ability for court security officers to be deployed around.
But we make sure they are where they need to be.
So can I just?
If it stops, I'll let Greg finish, then I'll go Rima, then you, Duncan.
Okay.
Anything, Greg?
So again, with the projected increase in the numbers going through the system, you know, with the changes in the some of the new, I suppose, initiatives within justice, will you be increasing the numbers there and
yes,
commensurate with that?
We did get some specific, notwithstanding that, you know, our last budget was a budget which reduced for us. We did get some specific additional resource for court security, reflecting exactly what you've raised. So I think we're increasing our numbers by about 20 over the current calendar year.
Well, thank you.
We're Rima, and then Duncan starts on this.
Just a supplementary. Recently I was at Manukau District Court, and I was having a korero with one of the gentlemen that's oversees the security, I think, from what I understood. And from what I understood, the level of security over there is on par with airports, if not more, from what I understood. And people are quite innovative with how they try to bring different weapons in. When you talk about the increase, the concerning increase, do we have kind of like a figure of what type of increases in percentage we're seeing with respect to security?
We do
incidents?
have figures. Do you?
Yeah. So in the 22-23 year, we had just under 2,500 incidents, and across the country, and in the last financial year, about 3,500. So it gives you an indication of the type of increase that we're seeing in terms of the incidents in the courthouses.
And from what I understood, people, whether they're staff or not, don't get a free pass. Everyone has to wait in the queue.
It's not quite accurate. So if you have one of these, so if you're an MOJ employee or if you're a judge, then you don't go through security. You can access, and you have free access around the court, but essentially everybody else does. So your lawyers do, and it's a constant source of dissatisfaction from them. They have to go through security as do others. Judges don't, and uniformed police officers don't, and my staff don't.
Thank you.
Thank you, Duncan.
So in terms of court security and safety, I see that at some point in November, there was some incidents, particularly in Wellington and Napier, and they were investigated by WorkSafe. And you were issued with something which I don't really know much about, which is called a sustained compliance letter. And I guess there's two aspects to this. There's risks that have been identified. So essentially there was an investigation, they found there was a health and safety breach, and then it's being proactively worked on to address those risks, and there's short and long-term projects. Can you just tell us what those short and long-term projects to address those risks are? And if you want to talk about the breaches, you can do that too.
Yeah, sure. So the sustained compliance notice that we got for those two instances, basically in a nutshell, is that WorkSafe found that our practices did what they were expected to do. There was some areas that we needed to tighten up on, and that they would expect us to continue to do what we have been doing with some enhancements. The key things that came out of the WorkSafe investigations were the public gallery barriers that Andrew talked about already, making sure that those were at an appropriate level, and also the dock upgrades. So in both in Napier and Wellington, specific facilities upgrades that we were doing. So in the case of the Napier dock, that we had that on I think to be done in a year or two. So we've got a national upgrade program for the docks. We brought that one forward and got it done really quickly. The other thing that was in the letters was have been working on a security MOU with the judiciary. So obviously the judiciary and the ministry under the Health and Safety Act have different obligations within the courthouses. They've been really clear on roles and responsibilities in the courtroom. And so the development of that security MOU, which is nearing completion, was one of the things that we talked to WorkSafe about and that they were keen to see us put in place.
And I'm aware that you've been in the media recently in respect of risks to lawyers. I know certainly I think it was the Auckland Law Society, Law Association had some observations on that. Are you doing anything in particular in respect of the concerns raised by that association, risks to lawyers?
So there's probably two main items in there, I believe. So one was around frosted glass on interview rooms. The frosted glass was put on those interview rooms in conjunction with the Law Society when it was done. We're actually going to write to the Law Society shortly, given that's come up, and actually invite them into a conversation. Is that something we want to revisit? Cameras in lifts, CCTV in lifts was another one. The ministry, we've got a health and safety committee. We're actually considering that next week. So we've had a position on it. We're reconsidering our view on that. So some advice that's coming to our peak sort of health and safety governance.
So you're looking at putting cameras in those lifts?
So there's some quite. So we have to work through the advice that we've got from our team and have a look at that. So we'll consider that next week. There are some limitations to putting cameras in lifts. Many of our lifts don't have the ability to actually put cameras in. The cabling is problematic to put in. We do have cameras in the Christchurch District Court, part of the big precinct there. That's the only one that has cameras in at the moment.
Okay, we'll go to primary from Lawrence, then Paolo, then Rema, and then if we get time, Greg.
Thank you so much, Mr. Chair. My question is around youth justice.
Sorry, there's 5.5 minutes left as well, by the way.
Okay, I only actually got one question and one sub. The primary question is what multi-agency approach are you taking to look at prevention of youth crime in the first place? And I think the two main agencies I'm thinking is MSD and MOE. So is there any multi-agency being done? And are there any specific focus areas such as Māori youth or Pacific youth?
There's a big program in looking at assistant youth offending and the sorts of wraparound care that can be done with that. It's also Oranga Tamariki is the other agency that's very active in leading that. Our main involvement in that space is actually in the policy area, where we would be providing support more around legislative fixes to take forward. So I mean, I won't speculate or talk to what those other agencies are doing, because it's more, I think, in their space than ours. There is some of the same issues that were raised earlier about looking for, local solutions that actually wrap around information and care around young people. And you can get to those through a variety of ways. You could get to them through a Ringapahi court. More often you might get to them because the police pick somebody up and they bring it into an OT facility, and they actually will have a table where you bring the different agencies and try and say, what's actually going on with this troubled youngster and what might we do about it? So there's a lot of operational activity. We tend not to be at the forefront of that because, where our role is more in the courts and in the policy space. So that it'd be police, it'd be oranga tamariki, education would be the main places that you would talk to about that.
One supplementary question on something that potentially is in your remit is sort of around the pilot military style bootcamp, and also what will be the implementation. What is the Ministry of Justice role in terms of monitoring and evaluating that particular pilot?
Again, we don't have a specific role in monitoring or evaluating the pilot. We do support oranga tamariki in some of the broad policy settings that they do. So in that context, we will be interested in the results of any evaluation or pilot of those facilities, but it won't be us that's undertaking them. We'll be informed by them as we bring our policy advice.
Great, thank you, Lawrence. We'll go to Paolo and then Reem.
Andrew, clearly you and your team have been super hardworking and very busy.
Yeah.
We earlier talked about the need to articulate that to the visibility of the public, right?
Yeah.
And particularly what outcomes are being sought and whether they're being achieved. It's something of keen interest.
Yeah.
So the performance reporting is so important. Particularly because they will tend to support appropriation and funding to do the good work that you're doing. My question has to do with whether you as the lead, sector lead for corrections and everyone else and justice and police, whether you're collaborating towards a joint or a way where all the sectors look at funding and requirements for funding in a collaborative way as well, because you're working collaboratively, and the demands for appropriations towards each of the jobs that you're doing might benefit from a collaborative. Is there a plan?
I think the answer is probably yes and no and yes. And the first yes, I mean, we have over the last few years worked as a justice cluster, and that was, it wasn't all of the agencies at JSLB, but because it didn't have oranga tamariki in it. And we did that over budgets, including and up to the 24 budget. So the 24 budget was more a budget of reducing expenditure than it was a budget of increasing expenditure. That cluster is not formally in place anymore. So that's the yes and the no. But the other yes is we are still being encouraged by ministers, and we are working together, particularly in those areas where we have a common interest. And the obvious one is the two that we've talked about, particularly in the courts timeliness space, because whilst it's courts timeliness, it's actually justice sector timeliness, because of that's where it all comes. And we are talking about the resources. So the police prosecutions uplift work is something that was effectively jointly funded, and it's an area where we are talking about how we ensure that the resourcing for that continues and is found. And we are sharing our information and being informed by each other. But we are still separate agencies, and we won't have a common vote across and above it. So we probably spend a lot more time sharing and testing and understanding each other's budgets than any other group of agencies across government, but it's not as formal as it was when we had the formal justice cluster in place.
The timeliness, access to timely justice,
yes,
and its impact on remand will.
Well, it's all integrated.
Yes.
So remand prisoners are more expensive than non-remand prisoners. We have more remand prisoners if we don't have if the courts are not functioning properly. The courts might not be functioning properly if there's some shortcomings in police prosecutions or the legal aid settings are not right or whatever else. So all of this stuff is connected. There's policy settings that sit over the back of that connects it all up as well. It's inextricably linked in with resourcing decisions, with policy decisions, and with operational decisions. And so that whole space has us connected. And I mean, we are meeting very intensively as a group of chief executives, particularly in that space. Every few weeks we're meeting, we're connecting. Oftentimes we will actually invite the Chief District Court judge for part of those meetings to come, because they have the role and work in a partnership that respects the different prerogatives that we all have.
Thank you.
Thanks.
Thank you.
Rema, there's a minute 40 left if you'd like your primary.
Okay.
I'll answer it
Thank
quickly.
you. Look, I noticed with respect to the people that work in your with you all, females are exceptionally higher than males. Was there a plan there, or did it just kind of happen organically?
We've been very conscious of our pay gap over the last few years. We've reduced it. I think it's down to 9.1%. We do have, I think we're about 2/3 women and 1/3 men. I think, more or less across the ministry, and that slightly varies in different areas. It's not really something that you set out. I hadn't set out with a specific target, but we have been mindful of balance, mindful of diversity, certainly mindful of the pay gap, as we have made a lot of those sorts of recruitment, promotion, etc. type decisions in the last few years. But fundamentally, you always do it on merit, and you select on merit, and then you merit is all equal. You might consider whether there are other things to take into account.
Yep.
Thank you, Rema. Thank you, Duncan. You've got the last 3 minutes, a little bit extra of the government.
We'll see how we go. Look, it's just a question around a briefing I was reading from December 14 on investigatory tools, which look quite, obscure, but quite important. And one of my concerns was that the briefing says that the ministry couldn't get on with that work because of resourcing constraints being sucked away by gang work. And also, I'm asking, in terms of the redundancies that you've gone through, whether that's impacted it. In particular, there was work on end-to-end encryption and the ability to access information for criminal investigations and intelligence. And so in terms of those works on investigatory tools, are you putting resources into that, or has the government priorities put that elsewhere?
If Ms. Anderson was still here, she would know the refrain that every Justice Minister knows, which there is more work than there is resource. And that, so we I think end up being a frustrating ministry for every minister we've had, because we've said, you want to do that, and our capacity is this.
Yeah, look,
in that world. I mean, so I don't know if Caroline is wanting to come back and talk specifically about the investigatory tools space. But look, we do have,
well, I'm
across the
interested
board,
to hear
there are
in
those sorts of
that part of the work program and its importance. But the briefing was quite clear that it was underway, but it's appeared to get pushed to one side because of the priorities of the government.
Well, every government has its priorities. I think we're still working in that space. We still have it. These things, we work out the phasing of them. But every Minister of Justice has dealt with how do I fit in my priorities.
It looked like a very important piece of work, like mutual assistance, encryption, bodily samples. It was really important stuff to be able to
specifics of that.
In DNA use modernising our DNA frameworks. Yeah. Can you just talk about where that works at and what its importance is?
We may have to get back to you on the very specifics.
Yeah, I was just going to say, I just know that it's Law Commission.
The DNA one is.
The bodily sample stuff, the Law Commission's working on, I'm aware of that.
Yeah.
But I'd rather hear you talk than myself.
What we have,
one sec, can you just repeat what the gentleman said at the back, just because
the Law Commission report has dealt with a number of these DNA type matters. Yeah. I mean, we can come back to you with anything more specific. My understanding is it's absolutely on our work program. It's probably not on our immediate and current one. We're phasing these things and we will get to them. But if I can go to reassure you, we have, our ministers have been impatient for more policy work, and we've worked quite hard to, as much as we can, protect that policy work through the savings type structure. And so we haven't,
So in terms of redundancies, this kind of work is not affected.
Correct. So our phase 2 change process didn't result in a loss of jobs from our policy capacity.
Okay, and when is this work likely, when is it likely the public will see something from this, like?
I'd have to come back with what we can say on that. I don't have in terms of the specific question.
Okay, that's pretty good. Nice, tidy way to finish up. Hey, thank you, Andrew, and your team for joining us this afternoon, for providing as fulsome answers to questions as you can. Just on some of those questions you weren't able to provide detail with, if you can follow up and provide that in writing. Otherwise, I think our team might follow up as well. And then maybe some post-hearing questions that come your way too. But can I just acknowledge the work of you and your team in what you do in justice, but also just for supporting our committee. You said at the start it's a busy workload, and we feel that. And as you rattled off a list of the things you're doing, it gave us a bit of slightly traumatic flashbacks as to the meetings we have been in and will be in. But just want to say thank you on behalf of the committee.
Well, can I thank the committee as well? And actually, following your cue, Mr. Chair, we probably have a busier work program on at the moment across all of the business, from the infrastructure through the policy and the like, than we've had, and that's supported by a whole lot of people working really, really hard. And I appreciate the committee's appreciation and acknowledgement of them. So thank you.
Very good. Thank you. Thank you, folks. Right, that concludes the public part of our oral hearings. We will now move